And frankly, I think a lawyer needs to do more than just legal work. I think he needs to know your business. He or she really needs to know your business. They need to know who you are, how you think, your culture, how you operate, your key employees, and your product. And the way I think an attorney ought to do that, in my mind, is spend some time with you. That might mean the weekends, it might mean evenings, and this is not billable time. This is just developing that rapport so you can give effective representation. I know some attorneys just don't seem to invite that type of close relationship. They want to do your legal work, they want to bill you, and move on. My problem with that is I don't think you can effectively do the legal work unless you know your client and your business. So there's a collateral part to all of that. I think attorneys ought to give good advice, but I think really there's certain lawyers out there. I used to say as they get older, now I like to say as they get more mature, who I think give good business advice. And I know a lot of business owners and people who have a great relationship with their lawyer, and their lawyer helps them make business decisions, help negotiate contracts, interview potential key employees. They really kind of become integrated with the business. And I think there's not enough of that, by the way. I think too much is just all about, we used to have a practice model, where we actually thought of ourselves as practitioners, and it's kind of an art to all of what we do. I'm talking to lawyers today, and all they talk about is their business model. It's all about business. It's all about money. Is this case cost effective? Is this client cost effective? Does this client pay timely? Something else I think about a lawyer. I think all lawyers, frankly, either should be a trial lawyer, or have trial lawyer experience, or have a good relationship with a trial lawyer. Because when you do what we do, at least with my clients, we do a fair amount of litigation. And if push comes to shove, we can't resolve something, and I'll tell you about it a little bit later, we file lawsuits, and we go through discovery, and we go to trial. The other side knows that. The other side knows whether you're willing to go to trial. And so what happens is, every time I look at a contract, if I'm drafting a contract, I look at that document and I say, someday a jury might see this. So be careful when you draft it. When you draft a letter, someday a jury might see it. So I'm cautious about the way I draft that letter. You see? And every time I see a document, I say, how do you lay the foundation if I want to get this into evidence? Who's going to be my witness to lay the foundation? So you begin to think a little bit differently. Well, I always believe that we should always be fair and do everything on a high level when we deal with anybody, including opposing counsel. But you have to have a tough enough spine if push comes to shove and you're backed into a corner. You ought to be able to go to trial and win for your client. I think something else, and I think Joyce might appreciate this, I think we should all know our limitations. There's lawyers out there they're like me. They know a little bit about a lot of things, okay? And there's other lawyers that drill down really deep. Certain probate lawyers really drill down deep. Certain bankruptcy lawyers who maybe do creditors' rights, They just drill down. That's what they do. Certain employment lawyers do that. I like those folks. And sometimes my client needs them. And sometimes I'm not the best lawyer to represent them in an EEOC matter or a bankruptcy matter. So you know what I do? And I think every lawyer should do this. I think that we should treat the very best lawyers that practice in the Phoenix metropolitan area as extensions of our firm. We should develop relationships with them. We should understand who they are and their practices. And so if Joyce or Ken or Marianne or anybody needs a lawyer that has that real estate or specialty skill, we can refer the client, maybe be the interface, stay on top of it, and make sure that we get a good result. I think we as lawyers need to be careful not to overreach and get our clients in trouble and not get them. There's another area for the business entrepreneur that I think you really need to think about, and that's a good CPA. I am amazed about CPAs. There's a lot of great CPAs out there. If your critical mass is large enough, it's nice to connect a CPA and a tax lawyer. All right. Some people can't afford both. But I have seen CPAs save their clients a lot of money. And then there's kind of this, there's the top 3 or 4%. Then there's this kind of like this mid-range that's maybe okay. But I will tell you, there's a bottom range of CPAs that look good. They tell you a good story. You think they're going to do a great job, and they can cost you a lot of money. They can cause you a lot of heartburn. So I think you've got to be really careful. I think on your team you should have a good lawyer, a good CPA, and a good insurance broker. We all know the types of insurance out there depending on your business. General comprehensive liability insurance. Errors and omissions is sometimes we call professional liability insurance. If you give advice. There's non-owned auto. I want to talk to you for a minute about non-owned auto insurance. What it means is this. Let's say you own a business and you need your secretary or one of your staff to run an errand. Let's say to go to the bank. And that person goes and takes their own car. And they're tooling off, going to the bank, and it's on a Friday, and they're thinking of their date that night, and they run into a busload of doctors. And let's say that the secretary that ran this errand for you has her own car, and she has minimum liability policy limits of $15.30. Well, next thing you know, you get a call from a very enterprising lawyer who says, my claim's worth $500,000, I got 15. Would you mind writing me a check out as the employer, because you're vicariously liable for all the damages that your secretary did to my client, so I need a check for $485,000 when I pick it up. Your insurance is not going to cover that, right? Unless you have something like non-owned auto insurance. So before you launch a member of your staff out to run errands, to take a trip to Tucson, be thinking about insurance and what happens if that person causes serious injury to somebody, or get non-owned auto, okay? Or give them your car, let them drive your car, because insurance follows the vehicle, and if you have $300,000, you're protected, you see? And her insurance is secondary liable, so you're better off loaning your staff your car, because then there's coverage if there's a catastrophic accident. You follow that?
No, I didn't know that.
Pardon me?
I did not know that.
Yeah. All right. Something else.
If they're 1099, they're not on your staff.
Well,
It's the same thing.
Let me tell you, a 1099 is an independent contractor, and theoretically, they're separate, and you're not liable for their tortious acts or their acts of negligence, except very resourceful lawyers will say, you may call that person an independent contractor, and you may 1099 them, but in reality, if you have enough control over the work they do, the time they show up for work, you provide the desk, the office, the equipment, the furniture, the leads, you know what? You can call that person a 1099, but a jury's going to decide whether or not that person is an employee or a true independent contractor. And if they find that this person is really an employee, even though you call it a 1099 or an independent contractor, you're on the hook for full damages. So the answer to that, okay for you? Okay. Something I wanted to talk about is like operating agreements and partnership agreements and those types of things.
Okay, you have 5 minutes.
5 minutes is plenty.
Okay.
Look, attorneys write operating agreements and they're about this thick. Frankly, I've read through many of them. I don't understand hardly a word in them. You know, I think there's in operating agreements there's certain operative language. Let's say it's an LLC and you have 2 partners. There ought to be a lot of personal language in terms of how you're going to treat each other, your relationship, how you're going to resolve disputes, what is your, what's the distribution of profits and losses going to look like? You know, what is your exit strategy? What if a partner dies? I mean, you may love your partner, but you don't necessarily want to be in partnership with his children, you know, or with his spouse, you see? And oftentimes, attorneys will write, you know, will file the right documents with the Corporation Commission, run off an operating agreement, put a few phrases in there about what type of business you're going to do, and that's it. And it's not enough. And I think they should have integrity agreements, non-disparity agreements. I think it should encourage the parties to have, if they have a dispute, to have open dialogue, mediation, binding arbitration, as opposed to lawsuits. But I'll tell you what I really think about operating agreements and partnership agreements. If anybody in here, well, about 9 of every 10 businesses that I become associated, that I represent people with, were partnerships that began happy, and 9 out of 10 are dissolving. People who have been through a divorce know what it's like. If you have, in a divorce, you have 1 spouse. In a partnership or an LLC, you may have 2, 3, or 4 what are like spouses. And and it could be a nightmare dealing with all of them and their attorneys. I think operating agreements ought to look like prenuptial agreements. You know, what do prenuptial agreements do? They say, hey, look, we're going to live happily ever after, but if we don't, here's how we're going to divide up the property. Here's how we're going to go our separate ways. We're not going to hire lawyers and go to trial and have disputes. It's all outlined in our prenuptial agreement. I think a good operating agreement, a partnership agreement, a contract ought to say, here's what happens if this business doesn't work out, you see, and avoid litigation. Because too many lawyers will get involved, they'll take all the money, absorb all the assets, and then settle the case. One last thing I want to just mention, and I'll sit down. I find that business owners are usually very good communicators, but there's a lot of people, some business owners and people they employ aren't such good communicators. They don't really understand conflict resolution. They may have good intelligent quotients, but not relationship quotients, not emotional quotients. I think there's a lot to be learned in this life coaching, okay, neuro-linguistics programming. I encourage everybody to look into it. Some of you already are doing some things like that. There's a lot of growth, and a lot of good business is about communication.